The Supreme Court's 2014 decision in Alice Corp v. CLS Bank International is being used to invalidate patents that were once enforceable. Minneapolis trial lawyer and Maslon partner Terry Newby explains why this is happening and when in-house counsel can use the Alice decision as a defense to patent infringement claims. Please welcome Terry Newby.
Good morning, and thank you, everyone. Today we're going to talk about the Alice decision, and for those of you who are not familiar with it, it's an interesting decision for a couple of reasons. First, the Supreme Court addressed one of the most fundamental issues in patent law, namely, what is it that you can get a patent on? So you would think that that would have been pretty well covered by 2014, but apparently it was not. Second, it was a 9-0 decision. So it was one of those rare instances where the late Justice Scalia and Justice Ginsburg completely agreed on everything. And so we're going to talk about how that case affected patent law and how in-house counsel can use it to help them. Now, there are basically two kinds of companies when it comes to patent threats. There are those who have received a patent threat from a patent troll, sometimes known as a non-practicing entity, and those who are soon to receive a threat from a patent troll or a non-practicing entity. If you have not received one, you will receive one soon, and they all read about the same. We represent this company, we own lots of things, we don't make anything. We buy them, you did something or might do something that we think infringes, and if you don't pay us, we're going to send in that guy, the dreaded patent troll enforcement officer. So, if you don't want him to come into your office, you can use this Supreme Court decision to defend against some of these patent infringement claims for certain types of patents. So, first thing, again, you would have thought this would have been covered pretty well, but what is it that is subject to a patent? What is protectable? And this is what the Supreme Court had to address. Basically, you can get a patent for just about anything as long as it's new, useful, and non-obvious. And there were some cases dating back to the 1920s and 30s that say you can get a patent for anything under the sun. So that seems to be pretty well covered. Basically, you can get a patent for anything. Except there are a few well-known categories where you can't. Laws of nature, natural phenomena, abstract ideas. You can't get a patent for those things because otherwise it would prevent anyone from human progress. So those seem to be pretty well-established principles that you can't get patents for these things. The problem comes in when we talk about what exactly is an abstract idea. And with the advent of the internet and computers, a lot of companies were taking these well-known business practices, loan processing, for example, evaluating livestock, evaluating the mortgage process. You're taking all that stuff and simply putting it on a computer. And so that required the court to sort of periodically review what we mean by an abstract idea, because we still want to have that broad scope of what is patentable, but yet you can't get a patent for certain things like algorithms, mathematical formulas, hedging or protecting against risk. Those are well-known business practices that have never been subject to patents. So in 2014, the Supreme Court, no doubt thinking it had trod on some well-covered ground, is asked to address a patent where the claims were for using a third party to mitigate settlement risk. So somebody had a patent for, we try to settle disputes and we use a third party to help us mitigate that risk. Now that seems to a lot of people like a pretty well-known concept. It doesn't seem like something that you would be able to get a patent on since settlement and mitigating settlement risks have been around for a long time. And so the court adopted what they call the two-step test of patentability. So first you have to figure out whether these claims for mitigating settlement risk, are these directed to a patent-ineligible concept? And if the answer is yes, then we do the second part of the two-step. We have to make certain that it's, and I like this language, we look for some kind of inventive concept. So it's an element or combination of elements to make certain you haven't actually gotten a patent for something that you're not supposed to. It seems a little bit like the Potter-Stewart definition of obscenity. We know it when we see it, except it's not quite that bad. So they're giving us some guidance as to what they can determine whether or not you can get a patent for this otherwise ineligible concept. And the Alice patent failed the test because it was simply a concept of mitigating risk using a third party. Putting it on a computer doesn't do you any good. That patent is invalid. Now, seems like a pretty common sense result, but that decision has opened the floodgates. Courts since 2014 have been inundated with requests to invalidate patent claims. And the courts are not just throwing those claims out, not just eliminating the patents, they're doing so with no discovery. They're throwing these things out on Rule 12b motions, Rule 12c motions. No claim construction, no discovery, no depositions, nothing. You file one motion, the court looks at it and says, yeah, we think this is a patent ineligible concept, so dismissed, your patent's invalid. That's a pretty remarkable change, because in the old days, say 2012, to get a case thrown out on ineligibility under 101, the court would have to do something called claim construction. They'd have to read the claims, determine what the claims meant. They would have to have some discovery. They'd have to have someone come in and say, this is what this patent covers, this is what it doesn't. You'd actually have to have some discussion on the record as to what type of patent was at issue before you could get it thrown out on a Section 101. Post-Alice, in the brave new world of 2014, you don't really need to do that anymore. Courts will throw out patents on the pleadings without any discovery whatsoever. So, you know, this notion of how do we determine whether or not a particular patent is covered by Alice. Claim construction is something that the courts, as I said, used to have to do all of the time. You would have to actually review the claims and figure out whether the patent was something covered under 101. Courts no longer have to do that. In fact, in the content extraction case, the court said, well, we don't have to, it's not an inviolable prerequisite. It used to be a rule. Now it's more of a guideline, and we can do it if we want to. Same with the Clear with Computers case, and my personal favorite, a case from earlier this year, where the district court in Pennsylvania said, yes, claim construction is desirable unless, when reviewing the patents at issue, we decide that it is not. So this starts to sound a little bit more like the definition of obscenity. We'll tell you when we need it, and if we don't need it, you don't need it. It's desirable unless we conclude that it is not. So that's actually pretty good for those of you who are faced with or soon will face one of these patent troll infringement letters. I say patent troll, that's a pejorative term. They don't like that. It should be non-practicing entity, patent assertion entity, patent aggregator. Use any term that you like. So I won't use the word troll anymore. It's pejorative. So how can we tell if this is something? So you're in your office, you get this letter. How do you know if this is the type of patent where you can get it easily thrown out on a 12b6 motion? Now, if the patent in question is a well-known business practice, hedging bets, loans, loan processing, there's one for evaluating the price of livestock, which is a practice that was well-known before the internet. If it's nothing more than taking a well-known business practice and sticking it on a computer, it's probably invalid under the Alice decision. And you should consider whether or not you can file an early motion to dismiss under Rule 12. A lot of the patents held by the NPEs fall under this category because they're easy to buy, they're easy to accumulate, and they can buy hundreds of these patents at once and then use them to accumulate value for their portfolio. But not all of the patents that you're going to see like that are invalid. In fact, there's been a spate of activity recently on just the pendulum is swinging a little bit. It used to be post-Alice, it was very difficult to get them thrown out. Pre-Alice, I should say. Post-Alice, it was very easy to get them thrown out, and now the pendulum is swinging back a little bit. And in May of this year, the Supreme Court, or Federal Circuit, I should say, had a number of different cases that were all over the board in the same month on the same issue, which makes it very easy for litigation counsel to provide good advice to your clients. So the first one was this case called NFISH, where they looked at the patented issue and said, this one isn't an abstract idea. We're not going to throw it out. This one's going to survive. It's not really an abstract idea. Instead, it's an improvement in the way that computers operate. So if your patent is method of making a website better, method of making a computer work faster, method of doing something to improve the process of the patent or the computer, it's probably not going to get thrown out on an Alice challenge. 5 days later, the same court, different panel, but the same court, looked at a similar patent and said, well, no, we think this one is invalid because it's nothing more than an abstract idea of classifying and storing digital images in an organized manner. Now, the patentee argued, based on recent precedent from 5 days ago, that actually this is the same thing. It makes the computer work better, it makes the computer work faster. All we're doing is improving the way the computer works. That's not an Alice challenge. And the Federal Circuit said, well, no, it isn't, because you don't actually make the computer work faster. You're just storing digital images in an organized manner, and that's something people have been doing since people have been storing digital images. So that one gets thrown out. So now you have two decisions on essentially the same technology issued within 5 days of each other. So the Federal Circuit has been busy, and so trying to distill some of what we can have from these recent decisions. If your patent claims, if you're looking at a letter and the claims are directed to specific improvement in the functioning of a computer, making it faster, making it better, making it more efficient, what have you, it's probably going to survive Alice. If it's nothing more than adding conventional computer components to loan processing or cattle evaluation, there was a patent recently that was thrown out for a method of evaluating the value of livestock by including, among other things, the reproductive capability of the bull by valuing how many calves the bull could produce. So you had someone who actually had to write a patent on bull semen. And that patent, thankfully, was thrown out for a lot of reasons. So, Alice is still a powerful tool. I'm going to skip that one here. So we've got this summary of these cases. In May, they have one that was not invalid. Say 5 days later, they said another one was invalid. Later, in June, they had a patent for a method of filtering content on the internet. And the patentee said, no, ours is a method of actually making the computer faster. When you filter the content, it makes it faster, it improves the process of the computer. We're good, we don't have any Alice challenge. And the Federal Circuit said, well, actually you do, because it doesn't actually make the computer better at all. It's just an abstract idea. And so there's kind of this divide here as to what you're supposed to look at when you're looking at some of these patents. And so if you are in your office and you are faced with, there's Alice, you're the in-house counsel, there's the patent troll, and you're having to decide how you can go back, the first thing to look at is, all right, what product do we sell? What do we make? Do we have something related to computers? If we're accused of infringing a computer process patent, if it's a method patent, that is probably something that you should look at for an Alice challenge. If it's not a computer process patent, if it's a thing, if it's a widget, if it's something that is actually useful in the marketplace, if it's a type of pen or a type of technology, that's probably not something that is going to be subject to an Alice challenge. Now, one of the challenging things about looking at whether or not you can get these claims thrown out, the easy part, the benefit is that there's no discovery. There's no claim construction. Courts are willing to throw these out. The hard part is that the Federal Circuit and the Patent Trial and Appeal Board are all over the board as to what they decide is patent ineligible and what isn't. So despite their best efforts, what we have right now is a situation sort of similar to the definition of obscenity. They kind of know it when they see it. And there's a couple of recent decisions, by recent I mean yesterday and the day before yesterday, that sort of bear this out. Yesterday, the news came out that Google managed to get 2 patents killed for the abstract idea of sharing videos online. So these patents have been asserted against Google. You share the videos online and you get to, share them with people. It sounds somewhat similar to, I think it's called YouTube. And so surprisingly, they had gotten a patent for that, and Google said, no, you can't really get a patent for that. It's an abstract idea. And the district court in Delaware said, you're right, it is. Sharing videos online is just a well-known practice in the industry. Now, the question is, how long has it been well known to share videos online? I think since YouTube. So it's not like we're talking about cattle evaluation. But something as relatively recent and modern as sharing videos online, that's no longer patentable and should not have been patentable in the first place, according to the district court. The day before yesterday, the Patent Trial and Appeal Board was asked to look at a patent for a bailment scheme. It was a method of tracking shipping containers. Now, this has been something that's been ongoing for a long time. Shipping companies have to track their cargo, track what's on them, and someone had taken the idea of taking the content of ships and cargo ships and putting all that information on a computer and using the information on the computer to basically track where all the ships, all the cargo was going and where all the ships were going. This seems like a pretty well-known idea. And the Patent Trial and Appeal Board said, yes, it is. So they held that patent invalid. So some of these seem pretty easy, okay? If you're presented with a patent for a method of keeping track of ship cargo, and people have been doing that for a long time, that's probably something that's going to be thrown out. Method of sharing videos online, anything related to technology, that's going to be a little bit different. Let's go back to that one. Oops. Anyway, we'll skip that one. So, for those who face this regularly, if you get infringement letters or letters from patent trolls, whatever you like to call them, carefully consider what it is that your product is, and consider whether or not you wish to take the time to actually make an Alice challenge. Because often the NPEs, this is a volume-based business, and they'll send a letter and they will actually go away with a very carefully worded response. I have a client now that has been threatened with lawsuit for a patent for loan processing online. It's literally taking information from the borrower, getting the credit rating, getting the credit score, and assembling all that information, but doing it online using a computer. That's it. That is the sum total of their patent. And they have sent that letter to probably hundreds of other entities, all of which have paid them some money to go away. So our strategy in that case was to say, if you sue us for this, we'll get your patent invalidated. And they went away because there are other fish out there that will pay them the money. So consider whether or not this is something that you should do as in-house counsel, and whether this is something that you want. Not all patents are subject to Alice. The ones that are, you can get rid of them very easily, and it will save a lot of money. And also consider that the courts will often grant this without any discovery, without any expert reports, without any claim construction, none of the things that you would normally expect to do in a case. You can get rid of these patent cases without any of that stuff if it's the right case. So with that, remember, you can't go back to yesterday, as Alice said. There we go. Because the Supreme Court has completely changed the landscape for all of us. So, thank you.